Hiya. So we have been through the assignments, we've been through the basics of law, and we've been through the basics of how the courts work. I'm not pretending we're going into great detail. If for detail on these subjects, you need to go back and refer to the lectures we did on each of these. So as you know, there's quite long lectures on each of these topics. But I'm just trying to jog your memory and help you just be really clear on what it is you need to know, the basics you need to know. You also need to, of course, look at do the reading that I give you each week from McNays, each week from McNays. But now we're going to move on to the issue of contempt, which is a really crucial topic, and we looked at this a couple of weeks ago. So let me just put myself down there, and yeah, we'll have a look at contempt. So I want us to look at the law, the key definition, and the defences. And so this ties in with the way I want you to structure your thoughts, remember. So just some recent examples of how contempt has had an impact. I mentioned a couple of these. We have Priti Patel, the Home Secretary. She's facing a possible action for contempt because she didn't obey the instructions of a court to provide housing for a particular person. So if you disobey a court, you can be found to be in contempt of court. That is to say that you're not obeying a court, so you're not treating a court with respect. And that's what contempt comes down to, is respecting the courts and doing what they say and observing their rules. In the middle there, we have the BBC. They've recently been fined £28,000 after one of their reporters was given access to a court hearing which was being held on Teams because of the lockdown, and not only the reporter but the editors at the BBC basically forgot their basic media law, which is that you cannot record or use images from a court case. Now, whether that's in person or whether it's over Teams or in any other way, shape or form, doesn't matter. You cannot do it. It's a contempt of court to record images from a courtroom. So it's important just to remind yourself that even in extraordinary circumstances, the basic laws of contempt exist, and that's a pretty hefty fine, £28,000. You can be pretty sure that the people involved got a pretty substantial ticking off as well, and it's the sort of thing where you could lose your job if you make a mistake like that. On the right there is one from the Manchester Evening News recently, where a woman who was facing sentencing by a judge lied and told the judge that she had just had a baby, and so therefore the judge took pity on her and spared her a custodial jail sentence. Later came to light that she had lied and that she hadn't had a baby, so she was hauled back before the court and prosecuted for contempt of court, because lying to a court, misleading a court, is contempt. You're not respecting the court, and she was then sent down for that. So she was sent to prison, not only for the offence that she'd initially committed, but also for the contempt of court, of lying to a court. So it's really important, and it affects people. You can see what the fundamental principle is. It's the court saying, do what I say. So you need to do that. You need to do what the court says. So structure your thoughts. That's what I want you to do. I want you to be able to, in each particular issue, be able to name the legislation, name the law. I want you to be able to define what that law says about the offence, and I want you to know about the defences. That's a really useful way to go into the exam. If you've got those 3 boxes ticked in your own mind for each topic, you will not go too far wrong when it comes to the exam. So let's structure what we talk about with contempt in that way. So first of all, the legislation. So Contempt of Court Act 1981, that's the legislation, that's the name of the law that applies with contempt, so you need to know that. So let's move on to definitions. So common law contempt, we spoke about common law contempt and said that it doesn't apply, it was not used very often. Common law, remember, is law that's come down to us through the ages. It's not specifically written down. But the definition of common law contempt is publishing material which creates a substantial risk of serious prejudice to proceedings which are pending or imminent. So it's anticipating proceedings which are going to happen, anticipating charges and court action. So it's significant in that it does say that there is a risk even if proceedings have not started yet. If you've got good reason to know that proceedings are going to start, then there is a risk of contempt. But the key words there are substantial risk of serious prejudice. So it's all about being either deliberate or reckless in the way that you behave. So just bear that in mind. There is a common law contempt, but most of your attention should be focused on strict liability contempt. So this is contempt which is enshrined within the Contempt of Court Act 1981. So this is the one you really need to focus on, and it's the one I've suggested you really focus your essay on. And so there's a specific definition for strict liability contempt. So this is publishing material which creates a substantial risk of serious prejudice. So that same phrase that we saw with common law contempt, but now it changes. So or impediment. So it creates a substantial risk of serious prejudice or impediment to active proceedings. So it's a slightly different definition for strict liability contempt. And the important thing there is you understand what active proceedings are. You need to learn this definition. So you'll certainly need to use this in your essay, and you'll certainly need to use this in the exam. There will be a question about contempt in the exam, and I expect you to be able to provide this definition of contempt to explain what kind of material provides creates a risk of strict liability contempt. So we've got that basic definition. So published material which creates a substantial risk of serious prejudice or impediment to active proceedings. So a couple of things there. Strict liability. So what does strict liability mean? I would expect you to know that. And that's all about your intent is irrelevant. So the court decides whether a risk has been created by the publication. So it's not a matter of you just holding up your hand saying, well, I didn't really understand, or didn't know, I didn't mean to. That doesn't matter. The court decides whether there has been a risk created. And just to note, the publication doesn't just mean printed words. It can mean speech, broadcast, anything you communicate to the public via the web or however. So anything you communicate can be held as being a contempt under strict liability. The other bit you need to be thinking about is when do they become active? Because remember that definition, creating a substantial risk of serious prejudice or impediment to active proceedings. So you need to know when proceedings become active. So that's when there's an arrest, when an arrest warrant is issued, slightly different. A summons is issued, when there's an oral charge, when the accused is served with a document specifying the charge, when an inquest is opened, and also when there's a summons is also issued. So the key things there are an arrest, summons, or charge. Remember those things and you won't go far wrong. Inquests are important. Remember, inquests are where a coroner sits in a court and decides on the circumstances of someone's death. They don't attribute blame. They don't decide if someone is guilty or innocent. They come to a verdict on the circumstances of someone's death, the where, when, and how someone died. In terms of an arrest, just flagging up there that it's really important that you are clear about the status of a case. So if someone is arrested, you need to be clear on have they been arrested, or have they just been voluntarily being interviewed by the police, is what they call helping police with inquiries. Because if they're helping police with inquiries, that's not the same as arrests, and proceedings are not active at that point. So you see what I mean, that things have to be really precise in your understanding of what's going on. If you're reporting on a case, you have to know, has someone been arrested or have they not been arrested? Has someone been charged or not charged? Has someone been released? Because obviously there's a point where proceedings cease to be active. So if someone is an arrested person is released without charge, then proceedings cease to be active. So you you can start saying more. But be careful, if they're released on police bail or what they call under investigation, then the proceedings are still thought to be, or still said to be, active. So again, you need to continue being really careful during that period if they've been released under bail or police bail or under investigation. If no arrest is made within 12 months of a warrant being issued, so it expires basically, then you can go back to being able to report what you want within the bounds of the restrictions from other areas of law. And you'll already know about defamation. That creates certain other restrictions that we need to be careful about, damaging people's reputations, being able to prove what we say is true. If the case is discontinued, so basically if it's dropped, the case ceases to be active. If somebody is acquitted or sentenced, so acquitted is found not guilty, as soon as that happens, the case is no longer active, and so therefore we can report information. But again, be careful, because if someone is found not guilty, we can't suggest that they are guilty, because then that would potentially be a defamation, would potentially be damaging their reputation. Because if they've been acquitted, they're not guilty, therefore we can't say anything which suggests that they are. Or if a defendant is found to be unfit for trial or unfit to plead, again, we need to we can say that proceedings are no longer active. So then that changes the circumstances, changes the risk to us for under contempt. Charges lying on file. So quite often, if there's a case where someone is accused of an awful lot of offences, it might be that the police either decide, or the Crown Prosecution Service decide that it's no longer worth pursuing a lot of these cases or these charges, and those charges will just be said to be lying on file. They will never get to court, even though the charge exists. If they're defined as lying on trial, then the case ceases to be active. So I put this together. I thought this might be useful to try and visualize what's going on about this danger zone of contempt. So that line there is, that arrow is a timeline. So there's a nice little clock on the left. So that's time going by. So at this point, an alleged crime happens. So somebody steals something, for instance. A little bit later on, the proceedings become active because a particular person is arrested, or there's a warrant being issued, or they've been charged with it. So that changes things at that point. So proceedings become active at that point. Later on, proceedings cease to be active because the person who was charged or arrested, they've either been acquitted, i.e. found not guilty, or they've been released without charge. Proceedings have ceased to be active at that point. So this is the danger zone between the point where proceedings become active, i.e. when there's an arrest, a summons or a charge, and when proceedings cease to be active. And that's when someone is either released or acquitted or found guilty as well. Proceedings are no longer active. And the reason that's a danger zone, because that's the point where you could potentially prejudice the case. There's a chance that there might be a jury involved, and that's where there's the most risk of prejudicing that jury. So between becoming active and ceasing to be active, we need to be really careful, and that's where we have to avoid saying anything which would create a substantial risk of serious prejudice or impediment to those active proceedings. So the sorts of things that you need to avoid talking about there is talking about previous convictions. So you mustn't mention someone's previous convictions, even if you know. You shouldn't be suggesting that somebody is of bad character or dishonest. That's up to the court to decide. You shouldn't publish any evidence that directly links the defendant, the person who's been accused. You shouldn't directly link them to the crime. Any suggestion at all that the defendant is guilty, so that's why we use words like alleged and they've been accused of this. We can't say that the burglar, Ian Wood, denies it, because that says that I'm guilty. So we need to say the person accused of the burglary, Ian Wood, denies it. We can't provide any detailed witness accounts which might contaminate evidence, and we shouldn't use a picture of the defendant if identity is an issue. So you're generally in a criminal case, you'll quite often, as a reporter, ask the police, is identity an issue? So is there a chance that there's going to have to be a witness to say, yes, I saw that person at that time? So if identity is an issue, if we start publishing pictures of the person who's been arrested, that could start contaminating the witness's memory. So we need to be really careful about that. There are cases where identity is not an issue, so that's not a problem. But we always need to be aware of when identity is an issue and avoid publishing anything in that period. Just a quick reminder about juries. Remember, these are the untouchables. Juries are protected specifically under the Juries Act 1974 and specifically under Section 20D. And that says that it's a contempt of court to obtain, seek, solicit, or disclose or publish any details of. So basically, if we report anything about any of the following, we're in contempt. So if we report any statements made during the jury deliberations, any opinions expressed, any arguments that were expressed within the jury room, or any votes cast by the jury on whether someone's guilty or not guilty, then that would be a contempt of court. So the bottom line is leave juries alone, leave jury members alone, and you won't fall foul of that. Just to make note as well that inquests, they do also sometimes have juries, so they have similar protections, so be careful of that. But as I say, the rule of thumb is leave jurors alone and you'll be okay. So we've talked about the legislation, and we've talked about the definitions, the key definition of contempt, strict liability contempt, publishing material which creates a substantial risk of serious prejudice or impediment to active proceedings. We've talked about what strict liability means. We've talked about what active proceedings means. So now we need to look at the defences. So there are key defences. So Section 3. So that's not knowing proceedings were active, and you'll remember you have to demonstrate that you did everything reasonably possible to make sure you check that proceedings are active. So it's not just good enough to say, well, no one told me. You have to demonstrate that you took reasonable steps to establish whether proceedings were active or not. So if you had gone to the police and asked, has anyone been arrested or has anyone been charged, and they told you no, but then it later on turned out that there had been, you could use a Section 3 defence to say, well, I checked, I was given the wrong information, and therefore I'm not guilty of contempt. And you'd need to have evidence like a timed note in your notebook. So your notebooks are really important that you keep them dated, and they are accepted by courts as contemporary records and as evidence of your activities. Section 4. Defence is a fair, accurate and contemporaneous report of court proceedings published in good faith. So that's a really important defence, and is the bedrock of good court reporting. Because if you think about it, if you go to court as a reporter and you're hearing what the prosecution is saying, that is prejudicial, isn't it? Because they're saying this person is guilty and here's all this evidence. Now the jury is hearing that, and that will be balanced against what the defence says. Oh, this person is not guilty, and here is their defence. So as a court reporter, you need to be able to report what's been said in court. Remember that principle of open justice. And so we can use a Section 4 defence to say that as long as our reports are fair, accurate and contemporaneous, that means published as soon after the event as possible in our next edition, basically, and we're doing it in good faith, that we can't be shown to have a grudge against the person involved, then we will be fine. And Section 5 is discussion of public affairs, and we talked through some examples of that. We talked about the thalidomide case and the case of Dr. Leonard Arthur and the boy who had Down syndrome who died under Leonard Arthur's care. So go back and have a look at those examples. But discussion of public affairs says that as long as you're discussing an issue raised by a court case, that's fine. You cannot be held in contempt of court. But the moment you stray into relating that general discussion to what's happening in that courtroom and suggesting that someone is guilty, then yes, you would be guilty of a contempt of court. The fourth defence is Section 10, the Shield Law. Now, this is the one that's set up to try and help us as journalists to protect our sources. The law recognises that we shouldn't easily be forced to reveal our sources as journalists. What I said to you when we discussed it back in week 2 is that it's not really a very effective defence, because it goes on to say that we are required to to reveal our sources if a judge deems it's necessary in the interest of justice, which means that if the judge decides, then they should go ahead with it. What I've said to you is that, and this is an ethical issue, that as journalists we should never reveal our sources. So that can potentially place you in a really difficult position and present you with a dilemma, because you have the law saying you must reveal sources potentially, and if you don't, it's a contempt. You have me saying, as a professional journalist, you should never reveal your sources. I hope you never come into that situation, but if you do, then think long and hard before you reveal a source, because that undermines the integrity of journalism generally. Okay, so that's the reminders about contempt of court. So I'll finish this video here and I'll move on to a last video all about defamation.